Hello students, welcome to lecture number 5 of practice series in the Clat lecture series. These classes are sponsored by Sri Jendra Rank Zone. I'm your mentor Shekhar Galot. Let's get head on with the question because we all know what we are doing and why we are doing so. Need not explain every time. A person who is usually of sound mind but occasionally normal may take a contract when he is not unsound mind. A generally means in the state of unsound mind and rarely becomes capable of. A generally is in the state of unsound mind and rarely becomes capable of understanding things. A can never make a contract. A can make a contract at any time whenever he pleases. A can make a contract when normal. A can make a contract only for his benefit. So ultimately applying the principle, a person who is generally unsound mind can enter into a contract only when he is going through his sound period, when he is in his sanity. So, applying the principle straightly, we get our answer that he can make a contract when normal. So, our answer here is going to be option C. Principle: an independent contractor is one who is employed to do some work for his employer. He is engaged under a contract for services he undertakes to produce a given result. And in the actual execution of work, he is not under the direct control or following directions of his employer. He may use his own discretion in execution of the work assigned. In general, an employer is not liable for the torts of the independent contractor, but the employer may be held liable if he directs him to do some careless act. Ramesh had a taxi cab to go to Delhi airport. As he started late from his home, he kept on urging the taxi driver to drive at high speed and driver followed the directions. And ultimately, due to the high speed, an accident took place causing injuries to the person. Ramesh would not be liable for damages because Ramesh did not know the consequences of such rash driving. Ramesh would be held liable for damages as he exercised the control by giving directions to the driver. Ramesh would not be held liable for damages because the driver was an independent contractor and not his servant. Ramesh would not be liable as the car was not owned by him. So now, usually an employer, and we don't even call the person an employer, usually someone who hires a private contractor is not responsible for the actions of the private contractor. If I take a cab and I go to airport suppose and the cab meets an accident, so whatever happens in the accident, that is the liability of the cab driver because he is not my servant, he is not following my directions. He is only a service provider as per his own expert and skill. So a hirer is not liable for the services of a contractor. But in some cases, employer or the one who has hired those services of the private contractor, hirer is the better term. If he starts directing him and he asks him to do some careless and reckless acts and something wrong happens, then he will become jointly liable with the independent contractor. So if we apply this principle number 2 in this case, now we come to the conclusion that otherwise driver would have drove on his regular speed, but he regularly kept on instructing him to drive on the high speed, and due to the high speed, definitely everyone knows high speed is a careless act. So that due to that careless act, he met an accident. So now, if we apply this, we'll get our answer that Ramesh would be held liable for damages as he exercised the control by giving directions to the driver. So we get our answer that is B. Mere silence as to facts likely to affect the decision of a person to enter into contract is not fraud. A sells to B, his daughter who is minor, a horse which A knows to be unsound. A says nothing to B about the unsoundness of the horse. B can take plea of fraud because she is minor. A has not committed fraud. There cannot be a contract between father and daughter. A has committed fraud. So now what would you say here? We have already discussed this question, isn't it? In another case. So the answer is B. A has committed no fraud at all. Answer is B. A has committed no fraud. A person is said to shoot the doing of a thing when he instigates, investigates any other person to do that thing. Mere acquiescence, however, does not amount to instigation. A person is said to instigate the doing of a thing when he instigates any other person to do that thing. Mere acquiescence, mere agreeing to someone. Okay, acquiescence means agreeing to someone tacitly. My friend says, I want to become an actor, I'll go to Mumbai. Though I don't believe that he can become an actor and he should not go to Mumbai, he'll waste his time and money. But because he is very petulant, he is not listening to any reasoning, I'll say, it's okay, you see what you want to do. So that is called mere acquiescence. And taking part, instigating is that I tell him that you go to Mumbai, you look like an actor, you can be like an actor, you act well, you look well, you dance well, everything is there. That is called an instigation. Now you understand what I'm saying. Instigation versus acquiescence. A says to B, I am going to kill C, and B replies, do as you wish and take consequences. Thereafter, A kills C. B abetted A to kill C. B is joint liable with A for killing C. B has abetted A by conspiracy. B has not abetted A to kill C. Now, if we apply this principle, we come to understanding that B has not done any positive act from which we can infer that B actually took part in the conspiracy or he instigated A to kill C. But if we look at it objectively, do as you wish and take the consequences. He is telling him do whatever you want. Obviously, no one can stop anyone. Plus, he is also warning him that you will have to face consequences. That means his act is mere acquiescence. So when you are acquiescing to something, it does not amount to instigation. So we'll get our answer. That is, B has not abetted A to kill C. The object of which one of the following writs is to prevent a public person to hold office which he is not legally entitled to. Now we have done all the writs. Okay. Prohibition lies when you want some activity which government is carrying on to be prohibited. Okay. Similar is mandamus when you want some activity to be carried on. Certiorari when some judge or a legal officer has overreached his power. Quo warranto is what is the warrant. Okay, what is the warrant by which you are sitting on this, which you are occupying this office? So quo warranto is the writ which is applicable to remove someone from public office he is not entitled to. Under the Constitution of India, right to pollution-free environment has emerged as a fundamental right from the right to life and personal liberty, freedom of movement, conservative culture, equality under Article 14. So, right to pollution has nothing to do with equality. It may be an offshoot of equality, but straight away it has nothing to do with equality. Conserve culture under Article 29. This conserve culture is limited upon the minorities and linguistic culture. This is not pollution per se. Freedom of movement, pollution will not curtail your movement. Life and personal liberty, your life, your quality of life, your dignity of life, your health is definitely going to be affected by the pollution. So it squarely falls under option A, that is Article 21. List pendants means, now we have discussed this in the maxims class. List pendants. List means a litigation. So whenever you see the word list, that means some litigation is being talked about. Pendants means pendency. So list pendants means a pending suit. Okay, a pending suit. Very easy. Which among the following was described by Dr. B.R. Ambedkar as the heart and soul of the Constitution of India? We have discussed it in the Constitution class. A person who framed the Constitution, a master of the Constitution, he is the one who drafted the Constitution. So when someone creates a code as beautiful and as lengthy and as detailed like the Constitution of India, and still you ask him which one is the favorite article, okay, it is very difficult, but he still goes and attempts and tells that right to constitutional remedies under Article 32 is my most cherished article. Okay, so right to constitutional remedies, you'll have to learn this. There cannot be any formula for this. Ori ultrum partum. Audi, you understand Audi? Audi is not the brand of the car we are talking here about. Audi means audition, isn't it? Auditorium, where you speak, where you listen. So Audi means hearing, something with the hearing. Okay. Ultrum partum. Partum means party. Partum means party. Ultrum means all. Audi all partum. Audi hear all parties. Giving opportunity of hearing to other side. So you get your answer, you don't need to go to other options. Audio ultrum partum, giving the opportunity of hearing to the other side as well. It is one of the salutary principles of natural justice. Persona non grata means, persona is word for person or personality. Okay. Non means not, grata means not acceptable. Okay, not acceptable. So non-person, ungrateful person, non-performance of a promise, or an unacceptable person. So person non grata here, it means person who is not acceptable as a person. Now you must be wondering what kind of person can be a person who is not acceptable as a person. We can say aliens. When I say aliens, I am not talking about someone who will come from a spaceship and land on the earth like a PK movie. No, I am talking about alien enemy. Suppose we are at war with Pakistan, so every Pakistani will become an alien enemy and an unacceptable person, person non grata. Or like the case of unregistered partnership, if the unregistered partnership goes to file a case, then it cannot do so in its name because it's not registered, and if it's not registered, it will be treated as a person non grata. Alibi means a plea by an accused that he. Alibi is the legal term which is used, means by a person that he was present elsewhere, underwent preventive detention, facing trial, remain in judicial custody. Okay, alibi simply means he was somewhere else. So when someone is alleged to be accused of an offense, like I say that B has committed that offense, if B can successfully prove that he was in London that day, and he can produce the electric air tickets or the passport stamp, and he can, then it is said that he has successfully produced an alibi. Alibi means he was present elsewhere when the crime was committed, so how could he commit the crime? It is like this. Which among the following does not belong to the right to freedom of religion? Freedom of conscience and free professional practice and propagation of religion, freedom from attending religious instructions or religious worship in certain educational institutions, freedom from payment of taxes or promotion of any particular religion, freedom of speech and expression. So if you see all these above options, they are somewhere having the word religion or religious in it. So that means they all belong to freedom of religion. Now what does not have a religious word attached to it? Option D, freedom of speech and expression. That is Article 19, a specifically different article, and we have discussed this in the Constitution class as well. So our answer here is option D. Question 118. Obiter dicta. Dicta means dictation. Okay, obiter means observation. Observation and dictation means judgment of a court in the case before it. Basis of judicial decision, direction by a judge, an opinion given by the court not necessary for the decision. Okay, so obiter is an observation, an opinion given by the judge which is not necessary for the decision. Okay, don't get confused between obiter dicta and ratio decidendi. Ratio decidendi is basis of judicial decision. Ratio. What is the ratio of the judgment? Ratio decidendi. Ratio is the basis of the judicial decision. Obiter dicta is when approaching to that decision, judge may have made some casual observation or general observations which do not become law. Ratio decidendi, when court interprets a law, it becomes binding on all authorities. That is called ratio decidendi. But obiter dicta is casual observations or sweeping remarks which are not applicable on all people. As per law, the minimum age for the marriage of a boy and a girl in India is 18 years and 21 years, 18 years, 21 and 18, 21 in both the cases. So now our option is going to be option C. This does not need much explanation. Only suggestion I will give you is you read the wording of the question properly. The question says marriage age for boy and girl. Usually people don't read it in a hurry and they just go for 18 and 21. They thought that it's girl and boy. But it's other way around, it's boy and girl. So it is 21 and 18 years. Okay. Which one of the following is not a directive principle of state policy under Part 4 of the Constitution of India? Organization of the village panchayats, promotion of adult education, provision for just and humane conditions of work and maternity relief, promotion of international peace and security. See, adult education is a subject which has caught up fire in the latest time. So, adult education and discussion of the promotion of adult education was never an agenda when the constitution was framed up in year 1950, or probably in 47 to 49. But village panchayat were there. Human conditions, maternity were there. International peace and security were there. So these are part of state policy under part 4 of the constitution. But adult education, even today, it is not a part of this duty or this directive principles. The governor of a state is appointed by the president on the advice of prime minister, vice president, chief minister, chief justice. Definitely prime minister, because president has nothing to do with the vice president, chief minister, or a chief justice. He deals directly with the prime minister or his cabinet colleagues. The president gives his resignation to chief justice, parliament, vice president, prime minister. Now in this question I told you that a president deals directly with the prime minister or his colleagues. So now when he has to give the resignation, whom will he give the resignation to? Prime minister? No. You usually do not give resignation to someone whom you have appointed. So prime minister is appointed by the president. So that means president is superior to prime minister. He may be having more power, he may be having less power, that is different. But president appoints the prime minister and president appoints the chief justice. So how can he tender his resignation to someone who he has himself appointed or he can dismiss? So why a president will give the resignation to his subordinate? Okay, but definitely president is the highest topmost post in the Indian hierarchy. So he has to tender his resignation. So he must have some option to present it to. So whom he will submit it? He will submit it to his junior, that is his vice president. Okay, he will submit it to his vice president. Who among the following holds the office during the pleasure of the president? This is also known as pleasure doctrine. That means you hold the office till the pleasure of the president and you can be removed from your office as and when the president deems fit. Governor, election commissioner, speaker of Lok Sabha, chairman of UPSC. Chairman of UPSC is appointed by the committee of cabinet. Speaker of Lok Sabha is elected by the people, a representative of people. Election commissioner, they are appointed by the president but they have a fixed tenure. All these have a fixed tenure. Okay, but there is only one person who is, though has been given a fixed tenure but can be removed by the president at his will, that is governor, and he is the direct agent of the president of India in the states. Okay, he is a direct agent of the president of India. Neither of them is the other three people are direct agent of the president of India. They all are servant of the president of India, but he is a servant as well as direct under the direct care and supervision of the president. So, governor can be removed using the doctrine of pleasure. Okay, sometimes this question may be asked as it is also known as doctrine of pleasure. Okay, so if it is asked like doctrine of pleasure, you understand what is we talking about here.
It's 4 o'clock.
125. A person is guilty of culpable homicide amounting to murder if the act by which the death is caused is done with the intention of causing death. Okay, a person is guilty of culpable homicide amounting to murder. That means a person is guilty of murder if the act by which the death is caused is done with the intention of causing death. Anil and Prakash are playing hide and seek. Anil hides behind a bush. Amar, who is on a prowl to hunt for rabbits, observing some movement near the bush and assuming a rabbit was hiding there, fires and kills Anil. Amar does not know that Anil was hiding behind the bush. The police prosecute Amar for murder. Amar would not be liable for murder as he did not have the intention to kill Anil. Amar would be held liable for the murder because he should have taken care to find out the target before shooting. Amar would not be liable for murder because it would be too much to expect him to identify the target before shooting. Okay, so sometimes there may be questions which may have just three options attached to them. Okay, so whatever questions we are doing, they have been asked somewhere in the Clat examinations. So that is why we are doing it. So if the question in the Clat examination had three options, we'll go with the three options. So the most appropriate option here is Amar would not be liable for murder because it would be too much to expect him to identify the target before shooting. Let me read it again. So the answer would be A. Amar would not be liable to murder as he did not have the intention to kill Anil. Okay. An occupier is liable to a trespasser in respect of some willful act intended to cause harm or done with reckless disregard. Okay, reckless disregard. A farmhouse belonging to Narayan had its fencing electrified. The object was to ensure that the farm was secured from any wild animals in the vicinity. There were clear warning about the electric fencing. A cricket ball hit from a nearby playground fell within the farm. Virna, a coach conducting a summer camp from the school children, attempted to jump the fence to retrieve a ball and got injured on account of electric shock. Viren filed a suit against Narayan for relief. Now let us see what options we have. Narayan will not be liable because Viren was a trespasser. See, Viren entered into the property. So Viren is a trespasser. So if he has suffered some injury, why would Narayan be held guilty? Narayan is just trying to protect his property, okay? Narayan will not be held liable because he had given sufficient warning about electric fence, plus he had given the clear warning about electrified fencing as well. Narayan will be held liable because he must have taken note of the adjacent playground. Now, this is something which spills the beans for Narayan. And now, this is the only appropriate answer here. Narayan will be liable, though he is very well in his right for protecting his property. Plus, he has given enough signs as well. But he failed to recognize that there is a playground in the vicinity and children may come. And children by nature are casual and careless, so they may get hurt. And he is putting electric shocks near a children playground. He should not do that. And plus, look at the situation. A coach conducting a summer camp for school children. That means it is a place where summer camps are also being conducted. So a lot of people come here, keep on coming and going. So everyone may not be aware that there are electric fencing around and ball may definitely go up or something may happen. So Narayan will be liable because he must have taken note of the adjacent playground. So this is our answer for this question. A careless person becomes liable for his negligence when he owed a duty of care to others. As the bus was leaving the platform, Basappa rushed and boarded the bus, keeping the door open. Virabba, who was standing at the edge of the platform, was hit by the door of the moving bus and injured. Virabba takes Basappa to the court demanding monetary compensation. Basappa is liable to Virabba for not having taken care to close the door of the moving bus. Basappa is not liable to Virabba as it was the duty of the conductor of the bus to close the door. Basappa is not liable to Virabba as it was the duty of the latter to take sufficient care while standing on the platform as not to expose oneself to such accidental harm. Now let us see the principle. A careless person becomes liable for his negligence when he owed a duty of care to others. Now in this case, this Basappa carelessly rushed and boarded the bus and kept the door open. And this door then, when the bus took a turn, this door moved with the direction and it hit this Virappa, and Virappa suffered some injuries. Now, why has this happened? This has not happened due to the carelessness of the conductor. He may be careless as well, but ultimate careless or negligent person here is Basappa. So our option is Basappa is liable to Virappa for not having taken care to close the door of the moving bus. Now we go to sedition. Whoever by words, signs, or otherwise brings into hatred or contempt or excites disaffection towards the government established by the law in India shall be punished with imprisonment for life. This is the law of the sedition. Sedition means you provoke people against the government, you are giving incitative speeches so that people take up arms or people go up on the anarchy against the government of India or a state government in order to conduct a coup or to throw away the ministers or the government in the power by illegal means. Okay. In a public meeting, Yashpal Reddy, the leader of an opposite party, thunders, "This is a government of scoundrels, bootleggers, and scamsters that deserve to be unseated. Teach them a lesson in the coming election by voting them out of the power." The government is contemplating to prosecute Yashpal Reddy. The government says you are calling us and you are inciting hatred against the disaffection against the government by giving your speeches. Now let us see what are the options available. Yashpal Reddy is guilty of sedition for having made irresponsible and inflammatory speeches against the government. Yashpal Reddy is not guilty of sedition as he is only exercising his freedom of speech in public. Yashpal Reddy is guilty of sedition as his statements would incite people to violence, leading to the breakdown of law and order. Now you all have read the principle. Now principle says you are inciting hatred or contempt or dissatisfaction toward the government. Okay. But now look at what he's saying. This is a ground, this is a government of scoundrel, bootleggers, and scamsters. They deserve to be unseated. He's saying they deserve to be unseated. Yes, it may constitute a sedition, but let us read further. Teach them a lesson in the coming election by voting them out of the power. Now, he is not talking to people to unseat the government through illegal means. Voting and removing a government by voting power is a legitimate way of electing and removing a government. So now, when he is saying you use your power of vote, then he is not talking about illegal means. Then, in this case, he is not guilty of sedition. Yashpal Reddy is not guilty of sedition as he is only exercising his freedom of speech in public. So you can criticize the government, okay? There's nothing wrong with that, but you cannot incite people to go take up arms against the government and create anarchy in the society. That is wrong. But definitely saying that the government is corrupt or criticizing the policies of the government or the leadership of the government and requesting people to vote against the government will not constitute the offense of sedition. Principle: the owner of a property who allows its use by another person becomes liable for the damage caused by its use by the latter. Okay, now the owner of a property who allows its use by another. Now A is the owner and B is allowed to use the property. Become liable for the damage caused by its use by latter. So if B is causing some damage, then also A would be liable. Okay, because A allowed B to do that. Tataya takes his car to the garage for servicing. Since his office is a couple of kilometers away from the garage, he requests the owner of the garage to get him dropped to his office in his car by one of the latter's assistants. The owners of the garage ask Jagesh, an employee, to do the needful. On the way of dropping Tataya, the car collides with a motorcycle owing to a negligent driving by Jagesh and injures a rider. The motorcyclist brings a legal action against Tataya seeking monetary relief. Now let us see whether Tataya is liable to pay compensation here or not. Motorcyclist will fail in his action as he should have brought an action against the garage owner in whose employment was Jagesh. Okay. Motorcyclist will not succeed as Jagesh, who is not the agent of Tataya in driving the vehicle. Motorcyclist will succeed as the car was driven by Jagesh with the consent of Tataya. So let us apply the principle. The owner of a property, who is the owner? What is the property here? The property here is the car. Who is the owner? Jagesh. Sorry, Tataya. Who allows its use by another person. Now, who is the other person who is using it right now? That is Jagesh. Becomes liable for the damage caused by its use by the latter. So if some damage is being caused by the activity of Jagesh, then Tataya, because he is the owner and he allowed the user of the property, he will automatically become liable. If both the parties agree upon the same thing in same sense, the parties are bound by their agreement. That is an agreement when both the parties are agreeing on the same thing in same sense. Sanjay wrote to Ritik offering to sell his horse for 20,000. Ritik wrote back, I agree to purchase your black horse for so and so rupees. Okay. For 20,000. Okay. Now, whether this agreement is right or not, the parties are bound by their agreement as they agree on the price and also on the goods for the sale. Now, they agree on the horse, they agree on the price as well. One has made the offer, other has accepted it. The parties are not bound by the agreement as the object is uncertain. There is no uncertain object in the contract. It is dealing with the purchase and sale of horse. The parties are bound by the agreement as the color of horse is only a question of detail. Okay. So now there is an issue. Okay, that Ritik says I'll offer to sell my horse. Sanjay says I'll sell my horse. Okay, sell my horse. And Ritik says I'll buy your black horse. Now, color of the horse is only a question of detail. Okay, so he may be having more than one horse, so he can check the color of the horse and he can give him a black horse for that price. So parties are bound by their agreement as the color of horse is only a question of detail, but if he does not have a black horse at all, then definitely the agreement will not be a valid agreement. People will not be bound for it, but if he's having more than one horse, we don't know how many horses he's having, so it's only a matter of detail. Question 130. A Delhi local newspaper called Ramanand Bazar Patrika, having wide circulation in Anandnagar, published on 1st July 2019 an article with a picture of Boris Becker, a world renowned tennis player, posing nude with his dark skinned fiancée. Now, Boris Becker is a world renowned tennis player. He is posing nude with his dark skinned fiancée. Fiancée is dark in color. Okay. And this photo is published in Ramanand Patrika on 1st July 2019 by the name Barbara Fultus. This is the name of the fiancée Barbara Fultus, a film actress, which was photographed by none other than her father. Okay, so he's posing nude with Barbara Feltus. Okay, and this photograph was taken by the father of Barbara Feltus. The article states that in an interview, both Boris Becker and Barbara Feltus spoke freely about their engagement, their lives and future plans, and the messages they want to convey to the people at large. For posing to such photograph, they are giving a message for posing to such a photograph. Article picturizes Boris Becker as a strident protester of the pernicious practice of apartheid. Further, it was stated that the purpose of the photograph was also to signify the love champions over hatred. That idea that love champions over hatred. Will the alleged picture classify as obscene material in India? Do we classify it as obscene material in India? No, according to Hicklin test, it will not classify as an obscene test. Yes, according to the community standards test, the picture will classify as obscene. No, according to the community standards test, the picture will not classify as obscene. D, both A and C. So if we check, we have discussed the situation as well. So in this case, just because someone is posing nude with his fiancée, automatically the photo will not become a obscene photo. We have to see what context they have shot the photo. They have shot the photo in a way they are giving a message against a social evil, that is apartheid, that is difference of color, discrimination on the basis of the color. Okay, and the photograph has been taken by the father of Barbara Feltus, sorry. So the photograph is not as nude as well. I've seen this photograph, so I can tell you this is not a nude photograph. But anyhow, according to Hicklin test, definitely it will not come as obscene. And according to community standard test as well, it is giving a different message. It will not classify as an obscene. So D, both A and C is correct answer. The difference between Hicklin test and community standard test is, now what is the difference between the Hicklin test and the community standard test? We did it in the crimes classes. The former focuses on the susceptibility of the minds of the individuals to get corrupted, while the latter hinges upon the context, intended meaning, and contemporaneous social cultural environment of the society. As per Hicklin test, a nude picture of a woman per se can be obscene, while as per the letter, the picture should be suggestive of depraved mind and designed to excite sexual passion in persons who are likely to see it. The former considers obscenity as a changing concept with changing times, while the latter does not. All of the above. So, in this, the correct answer would be A, because the former focus, Hicklin test talks about the minds, the effect of the item to the minds of people in whose hands this video, audio, or book, or whatever it is may fall, while the community standards test take care of the meaning and the message, what is the context and what is the contemporary social culture of the society. I mean, which society it is being published, is society advanced enough or not? So the answer is going to be first one. Question 132. The issue of obscenity is fundamentally related to which of the following? Freedom of religion of an individual, freedom of speech and expression of an individual, right to privacy of an individual, all the above. All the above. So, the issue of obscenity, it definitely does not have anything to do with the religion. Okay, you cannot have obscenity in the religion. So when religion option is not a good option, then all of the above option also goes out. Okay, right to privacy of an individual. So when something is obscene, definitely you cannot call it right to privacy. When someone is publishing a material which appears to be obscene, that means the person is not careful about his privacy. So right to privacy also not an entitled party here. So ultimately, right to freedom of speech and expression of an individual, right to issue of sanity directly hits and directly comes in conflict with this right only. It is based upon this right and comes in conflict with this right only. Freedom of speech and expression as an individual. So our answer is going to be option B here. An activist while being semi-nude An activist, while being semi-nude, allowed her body to be used as a canvas to paint on by her two minor children who were properly clothed. So minor children are properly clothed. This activist, she is semi-nude and children are painting on her body. She uploaded this video of hers on an online platform with a message that she intended to normalize the female form of her for her children and not allow distorted ideas about sexuality to pervade in their mind. An advocate who sees the video registered a case for obscenity against her. Is it a case of obscenity as per the community standard test? Is it a case of obscenity as per community standard test? Okay. This is a pure case of obscenity and she is spreading it. This is a pure case of obscenity as well as child pornography as the children were exposed to her nudity. This is not a case of obscenity because, as per the community standard test, the video must not be seen in isolation but in the contextual setup of the message that the has put on the normalization of female sexuality. This is a case of obscenity as per the community standard test, as the video was blatantly obscene. Now you decide yourself, what is she trying to do? Is she trying to promote obscenity for children or for herself here? She is trying to send a message across and she is trying to normalize her children with female body so that tomorrow when they grow up they do not see female body with different notion, or they may not have different depraved corrupt mindset which is uh, you know a threat to society nowadays. Okay, so that her children have normal uh, feelings toward a female body and have respect to the body as well. So she's trying to give a message. When you try to give a message as per the community standards, you cannot definitely come to a conclusion that this video was obscene video. So our option is answer C, option C. On 7th May 2020, a major leakage of styrene gas was reported from the plastics manufacturing plant LG Polymers located on the outskirts of the Visakhapatnam city. The accident took place when the cooling system of a polymer plant got clogged due to the mismanagement of the factory workers and resulted in turning the city into a gas chamber. The gas which leaked was styrene gas, which is a hazardous chemical under Rule 2E plus entry so and so rules. Principle 1. There is a principle in environmental law which is known as polluter pay principle. Okay. So now read this principle and as well as I'll detail you what this principle is all about. The doctrine of polluter pay is a well established principle of the environmental law which places an obligation of compensating the damage to the people who ought to reimburse it and also have the capacity to disperse it. Okay. The principle explicitly affirms that a person who damages or disrupts the environment has the absolute obligation to bear the cost of ameliorating the environment. In Enviro Legal Action versus Union of India case, the Apex Court of India held that a polluter is legally responsible to reimburse the individual sufferers as well as to pay for the revitalization of the damaged environment. So the polluter principle pay Polluter pay principle simply says if someone is polluting the environment and some people are suffering for that because of that, he'll not only pay a compensation to the people who have suffered due to that erosion of the pollution, sorry, erosion of the clean environment, plus he'll also pay for restoration of the environment. Okay, so suppose someone is has polluted a stream of river. Now he can be asked to pay money for bringing that garbage out for the cost involved in bringing the garbage out of the stream, plus if someone has suffered some injury. Okay, that is polluter pay principle. And then we have another principle that is called principle of strict liability, which we discussed. The principle of strict liability was established in year 1868 in the case of Rayland versus Fletcher discussed, where the court held that any person who uses his or her land in an unnatural manner and who keeps any hazardous substance on such premises would be held liable under the principle of strict liability for any damage occurred on the escape of such perilous substance. However, the person is liable only when there is no natural use of land. The principle also restricts liability when the escape is due to an act of stranger, act of God, for example, natural calamity, or due to the person injured, due to the person plaintiff the wrongdoer. That means the one who was injured was ultimately the one who caused the accident, or when it happens with the consent of the person injured or with statutory authority. Okay. Principle of absolute liability. This is a handmaiden of the Justice P.N. Bhagwati of the Supreme Court of India, who devised this particular liability. It is called absolute liability. The absolute liability is a stringent form of strict liability as it is devoid of any exceptions that were mentioned under the earlier principle. For the first time in the case of M.C. Mehta vs. Union of India, the principle implies that whenever an enterprise is engaged in a dangerous or hazardous activity that threatens the people working in the enterprise and those living nearby. It owes an absolute and non-delegable duty to the community that no harm will be caused. If harm is indeed caused, the enterprise will have to compensate for damages and can't use exceptions provided in case of strict liability. The enterprise can't claim that the harm has not been caused due to the negligence or that it had taken all reasonable care. So, what is the difference between strict liability and the principle of absolute liability? We discussed it. Strict liability came from the case of Raylan versus Fletcher, but strict liability allows you some exceptions as well. What are those exceptions? In which you're a person who has done something wrong or who has allowed the hazardous product to escape and to put other people on damage. What are the exceptions? Act of God, act of stranger, natural calamity due to plaintiff the wrongdoer, or voluntary non-fit injuria, consent of the person, or with the statutory authority. But absolute liability says if you are indulged in the non-natural use of land, if you bring something which is dangerous in nature, and if that thing escapes and causes damage to people, then whatever it may be the case, it may be an act of the god, or it may be due by the statutory authority, or maybe with the consent of person, or due to the wrongful act of the person himself or the wrongful act of the stranger, then also employer or the person who has kept such thing will be liable. In absolute liability means if you bring something unnatural on your land and that unnatural thing is hazardous thing, and if it escapes and injures people, then you cannot take any defense at all. Even if the person himself came in contact with that thing and got injured, then also he will be liable to compensation because of the principle of absolute liability. Under which of the following principles will the company LG Polymer be liable? Polluter pay principle, strict liability, absolute liability, all of the above. The answer is D, all of the above. Because in his case, he cannot take the exception of the provided strict liability as well, because this leakage of steering gas happened due to the negligence of the employees. Okay, plus absolute liability is always there when something like this happen. and plus polluter pay principle because he has damaged the environment, so now he must pay compensation for damaging the environment as well. So all options are applicable in this case. So our answer is going to be option D. As per the polluter pays principle, LG Polymer will be liable to pay. Now, as per the polluter pay principle, LG Polymers will be liable to pay what? Amount of money for restoration of environment only, amount of money for restoration of environment and compensation to individuals who suffered the loss, compensation to victims only, none of the above. Now we have discussed in enough detail, so he'll have to be so person who is as per the polluter pay principle, he'll have to pay compensation not only to people who suffer an injury, but also the cost of restoration of environment. So we'll go with option B. A company ABC Limited operates an industrial chemical plant in the city of Azadnagar. Due to an earthquake on July 2020, the wells of the reactors in the plant gets damaged, due to which the operators could not properly transport the hazardous gas for chemical vaporization, resulting in the gas leakage. The gas leakage resulted in the death of 12 workers of the plant and also some people living nearby the plant. In this situation, in order to justify the liability of ABC Limited, choose the best option. ABC Limited can be held liable under the principle of strict and absolute liability and polluter pay principle as well. Here, principle of strict liability is not applicable upon this person. Why? Because it is an act of God, and principle of strict liability allows people to take exceptions. Okay, so this goes out of the picture. ABC Limited can be held liable under the polluter pay principle as well as the principle of absolute liability, but can be exempted under the rule of strict liability. ABC Limited will not be held liable under any of the principles. ABC Limited will be held liable under strict and absolute liability principles, but the principle of polluter pay will not be applicable to this situation. Okay, now we find our correct answer. Our correct answer is ABC Limited can be held liable under polluter pay principle and principle of absolute liability, because absolute liability gives you no exception at all, and definitely polluter pay principle will apply upon you. An argument of LG Polymers that they did not know that the steering gas could leak, okay, is a strong argument and can reduce the liability under the polluter pay principle, is a strong argument and can reduce the liability under strict liability principle, is a weak argument and will not help in reducing the liability of LG Polymers under any of the principles, is a weak argument but may help in reducing the liability under the strict liability. In this, the correct option is it's a weak argument and will not help in reducing the liability of LG polymers under any of the principle. XYZ, a company operating a pesticide factory in the city of Rampur. On one day, due to the negligence of factory staff, there is a leakage of the pesticide gas, as a result of which many pests and insects which feed on the plantation crops in the nearby farms are killed. There is no harm caused to the people living nearby or the workers of the pesticide factory. However, the leakage was so humongous that it reduced the quality of air in city, causing breathing problem for some people living around the area. So this is similar case with the algae polymers. Due to the negligence of staff, the pesticide gas has leaked. Okay, now what is the effect of this leakage of pesticide gas? Only on pest and insects. Okay, XYZ will be held absolutely liable but not strictly liable. XYZ will not be held as under the strict and absolute liability principles because the leakage only killed the pest and insect. XYZ's liability under the strict and absolute liability principles will depend upon the injury as to whether the leak pesticide gas was a hazardous substance, activity, or chemical or not. XYZ will be held liable under the polluter pay principle. XYZ will not be liable at all under the PPP, polluter pay principle. So, our answer in this particular question is going to be option C. Okay, option C. Because definitely, when he is corrupting the environment, he is liable to restore it. Okay, and then there is absolute liability as well as strict liability, and he cannot claim the defense of strict liability as well. Why? Because his own employee has been negligent. Okay, so option C is the correct option. The principle of natural justice is derived from the word just natural of the Roman law, and it is closely related to the common law and moral principles, but is not codified. It is the law of the nature which is not derived from any statute or constitution. The principle of natural justice is adhered to all by citizens of civilized state and supreme importance. Natural justice means it makes a sensible and reasonable decision making procedure on a particular issue. Sometimes it does not matter what is rational decision, but in the end, what matters is the procedure and who all are engaged in taking the reasonable decisions. It is not restricted within the concept of fairness, it has direct colors and shades which vary from context. Basically, natural justice consists of three rules. Okay, principle of natural justice has now three rules. Now, what are those rules? Hearing rule that effective hearing, opportunity to hearing should be given to other one. Nemo jurex in causa sol, or the principle that no one can be a judge in his own case. Okay, no one can be a judge in his own case. I'm facing some technical issues with my laptop, so we'll have to wind up this class here only. We'll continue again with this question in the next session. Thank you.